Good morning and welcome to our Spotlight video where we discuss cutting-edge employment law issues in the news. I'm Tom Spiggle, founder of the Spiggle Law Firm, a firm that helps people who have been fired or afraid they might be. And I am thrilled today to be joined again by Sarah Basil. Thanks for joining me, Sarah.
Thanks for having me, Tom.
And I know we want to talk about sexual harassment cases and arbitration. So I'll let you take it from there.
Sure. So one of the things I wanted to talk about was a new act that just is going into effect. I think it was in March of 2023. And this allows anybody that has been sexually harassed or sexually assaulted in the workplace to bring a suit, basically, and get out of their arbitration agreements.
Yeah, and this is, particularly powerful. And I forgot to mention, Sarah, what you do. You are a rising 3L, right? Or are you
Right.
rising 3L,
Mhm.
going into her final year of law school and is now working for our firm for the summer, which is fantastic. So for arbitration provisions are common, and for people who don't know, arbitration is sort of almost like a private court system where you go and you generally have a kind of a 3-judge panel, and these folks are, as they should be, or are paid. They're part of they're part of the arbitration system. The findings are not public. They tend to be the system. The idea is to have a streamlined litigation process, so things are moving along more quickly. There's less discovery, and so it's less expensive for the business, which can be great if you're dealing with business disputes. It helps both sides keep costs down. It's not so great if you're an individual plaintiff, particularly in sexual harassment cases or sexual assault cases, is because it allows the company or the defendant to keep it hush hush, right? To send it to arbitration. It's not part of a public court docket, and the general feeling, at least among people who do what we do representing employees, is that arbitration, while not always bad for employees, tends to favor the employer.
Right.
Yeah. So you want to talk a little bit about that?
Yeah, well, that is actually really interesting. And it is, beneficial in the sense that a lot of times it is a lot less costly and litigation is extremely costly. But I know a lot of employers in the arbitration clause have the power to choose who the arbitrator is, which makes a really big difference.
Yeah, absolutely. And for these arbitration panels, and I think probably judges, the panel members, try to be fair, but they're human beings and fallible like the rest of us. And these corporations are going to be before them maybe many times, right? Because we're talking large corporations that are part of these arbitration panels because they want to be, because they want to resolve disputes that way. So the chances that a defendant, particularly a large corporation, is going to end up before that panel or a member of that panel again are pretty high. The chances that an individual plaintiff is ever going to be in arbitration again, not to mention before these same panel members, is very, very low. So, and who's footing the bill for this? It is the employer, the defendant often, who is footing the bill for it. So, when they're paying your salary, essentially, I think it becomes harder to be disinterested. And that's not to say that arbitration panels are, the fix isn't always in for the company, but it does tend to be more employer friendly. And again, one of the pieces of leverage for a sexual assault, sexual harassment case, as it should be, is negative public pressure. Like if you file that in court, it's a public record. The press picks it up. Anybody can go down, can go to the electronic filing system and pull that complaint. And there's a public. It's for anybody to see. And for a company that's facing a really embarrassing, potentially embarrassing for the company, sexual harassment charge, that puts a lot more pressure on them to settle, to come to a resolution. And if they're in arbitration, not so much.
Right.
So you said this went into effect in March, and essentially, if you are with one of these kinds of cases, even if you have signed an arbitration provision, and a lot of times we sign these for credit card statements and all kinds of situations, like we sign agreements that include arbitration provisions. including employment contracts. So when you start with the company, you're signing, these are the good days, everybody's happy, you're signing all kinds of stuff, because you're getting ready to start the job. And it can include an arbitration provision. And this law says, like, hey, if it's a sexual harassment charge or sexual assault charge, you plaintiff, you the employee can file this in court. You're not bound by that arbitration provision. Is that right?
Right, exactly. And it's also important to note that just because you have an arbitration provision in your contract, in your employment contract, doesn't necessarily mean that you always have to arbitrate. There are ways out of that, especially for like discrimination cases. But this law does really help workers like get out of those agreements, and it's really important.
Yeah, yeah, and I'll just say finally, for those employees, or plaintiffs who can't get out of an arbitration provision, it's not the end of the world.
Right.
Employees do win arbitration cases. I mean, you can still bring your, bring your lawsuit essentially. So it's not the end of the world. It's just on balance, it's better as a plaintiff to have the option to file in federal court. Than to be bound by an arbitration provision. So this is a very positive thing, particularly for people who are facing sexual harassment, sexual assault, kinds of issues in the workplace.
Exactly.
All right, Sarah, this was very interesting. Thanks for joining me today, and I'll let you get back to the next thing on your desk.
All right. Thanks for having me.
Take care. Bye-bye.